Welcome back. How lawyers can be effective advocates was the subject of discussion at a training for lawyers and law students organized by the Conference of Western Attorneys General CWAG United States. CWAG, through its Alliance Partnership, is a cooperative program aimed at strengthening the legal systems of US, Mexico, and many other countries. The three-day training was organized in collaboration with the Nigerian Institute of Advanced Legal Studies and the law firm of Punuka Attorneys and Solicitors. The theme was oral advocacy in Nigeria.
A former director of public prosecution, DPP Lagos, Mr. Fola Othowori, says that cross-examination is the most effective tool to challenge the opposing party's case. He spoke on the topic cross-examination, basic principles and techniques in criminal and civil trial. For him, a counsel's duty is to use his opportunity for cross-examination to change the court's perception of the case of the opposing side.
In a criminal case, a party would consider its cross-examination successful if such witnesses at least accept that particular aspects of the case put to them are probable. You've described a wound, doctor, to the back of the deceased's head, right? You said that in your opinion, that wound was caused by a blow to the back of the head with such and such object was. But it's also possible, doctor, that such a wound could also come from a fall. Yes, in some cases, thank you. That's all. Don't go ahead. Tell us what type of... Stop. So you've introduced that, but it has to tie to you can't just bring it out of the blues. You have to have some element of your case that supports that opinion. So, in civil cases, the goal of cross-examining counsel is to put to each of his opponent's witnesses in turn so much of his own case as concerns that particular witness, on which he had any part, and to get the witness to accept them as true or at least probable or plausible. So you want to change the court's perception of the other side's case through your cross-examination.
A Deputy Chief Criminal Division Rhode Island Attorney General's Office, Scott ERICKSON, who spoke on fundamentals of oral advocacy, urged prosecutors to make effective use of plea bargaining.
I can tell you that certainly in the U.S., it happens the majority of time. I would guess that in my jurisdiction, like I said, we've got about 1 million people. We probably average about 6,000 or 6,500 felony charges a year that our office prosecutes. We have maybe 40 or 50 prosecutors that are going to handle all those cases. Of those cases, we probably try about maybe 200. So if you do the math, you're talking 5,800, 6,000 cases that are somehow disposed of every single year by some type of plea negotiation. The system couldn't handle it, at least from where I work, if every case went to trial. It just couldn't handle it.
Another of his colleagues talked about some other differences between the two jurisdictions.
From the civil law point of view, what seems to be the most different is that direct examination, direct evidence is presented in writing rather than by examination, oral examination. From a criminal side, I would really defer to my colleague Scott ERICKSON, who talked about it. For example, today Scott talked about that cases are in the United States are generally decisions made as to whether or not they can go forward by use of a grand jury, which I understand is not the case in Nigeria. Oh, and I'm sorry, pretty clearly I think a very key and salient difference would be that in Nigeria, as I understand it, the trials are not by juries, which, as Scott mentioned today, is a pretty key element of United States practice.